Hello dear learners, today we will start with the course Ethics, Theories and Application, and the topic will be Human Rights Part 1. My name is Shruti Sharma and I am an assistant professor at Delhi University. So we will start with the objectives of the course. We shall seek to understand the important aspects of rights in this unit. First, by briefly expounding the different foundations of human rights, then by giving a brief account of the historical development of human rights. We shall also critically evaluate human rights. Special attention will be given to the rights to life as this unfolds the relation between ethics and human rights in general. Let's start with a definition of rights. A simple working definition of a right is that it is a well-founded claim. Historically, various bases or foundations have been put forward to ground different rights. We will need to critically assess these in a moment. So we start with the British empiricist philosopher John Locke, 1632 and died in 1704, who inspired the writing of both the American and the Indian constitutions. He recognized that the free gifts of nature, that is, land, forest, the water in lakes and rivers, fresh air, the flowers and fruits that grew widely, belonged to no one, but if you mixed your labor with any of them, you acquired a right to private property of them. Additionally, he says, the water in the stream belongs to everyone, but the water that I went and fetched in my bucket belongs to me. The trees in the forest are anyone's, but the one I cut down is mine. So too as regards the fruit and flowers that I have carefully picked. Now this appears to be quite a lucrative theory. The question arises, what if I put my labor to erecting a fence around a whole lake? Does that entitle me to private ownership of this entire free gift of nature, such that I can reserve its watery wealth all to myself, or perhaps charge a fee to anyone who wants to draw a bucket from it? Marxists, as we know, have no problems with private ownership of consumer goods. These are goods that we use or consume directly, such as computer, bicycle, food, a house, clothes, and so on. But they firmly oppose to private ownership of producer goods, that is, goods that are used to produce other goods, such as factories, fuel, tools, agriculture land, and so on. However, not everyone would agree with their anti-capitalist ideology. Some rights, such as the right to life, liberty, and free speech, are allegedly rooted in our very human nature and so are inalienable. That is, no one can deprive us of them. With regard to these rights, there are some seminal issues. Let us consider these issues. How many are these rights and which ones are they? Has the state the right to curtail them in emergencies for a limited period? And has the state the right to execute capital punishment? If so, on what grounds shall we consider that? These are some of the issues which we will explore in this chapter. Now let's start with the explanation of rights. As different rights may claim to different foundations, it might be worthwhile to classify them according to these sources, to avoid confusion and misunderstanding. Now, perhaps the most important basic distinction we can make is between positive and natural rights and their corresponding duties. A natural right, as the very term indicates, is one that is founded on our very human nature. For instance, the very fact that we are embodied beings lays upon us the duty to take reasonable care of our bodies. Whence arises the fundamental human right to food, clothing, and shelter. We have a right to adequate supplies of these, along with the proper means to obtain them. That is, the right to a decent job and a living wage. Before going further, a word of caution is in order. We should make proper use of our human qualities of intelligence and freedom and not overindulge in any of our appetites, such that we ruin our health in the process. This also means that we recognize that other persons have an equal right to such goods, and we may not go on an unbridled spree of having more, amassing private supplies of the above-mentioned necessities, such that other persons are deprived of their possibility of access to them. Now let's understand what are positive rights. Positive rights, on the other hand, are those guaranteed to us by virtue of law. Thus, the laws of the state lay down who has the right to vote. Usually, it is a citizen of either sex who has passed the legal age of 18 years. Now, inasmuch as an authentic natural right is rooted in our human nature, no individual or organization can take it away from us. Natural rights are thus inalienable. Our various constitutions actually do not grant us these rights. At best, they merely recognize and guarantee them. A particular state may refuse to acknowledge a particular natural right, in which case it would be acting beyond its proper power. It may legally prevent a person from exercising his or her human rights, but it can't really remove one's claim to them. Few, however, would deny that states' right to suspend, in an emergency, certain natural rights of the citizens temporarily for the common good. Thus, during a flood or in the aftermath of an earthquake, the state may request private agencies to transport food and medicine to the affected areas or to rush the injured to hospital. Some amount of freedom of speech may be curtailed in times of war. In case enemy agents have any access to information that would jeopardize the security of the nation and its citizens. Now let us understand the development of human rights. It is pertinent to note that the initial points of rights were mainly freedom, security, property, and resistance to oppression. It is stated in Statement of 1789, which are inspired by liberalism and are considered as rights to be protected against the state. Later versions add the concerns of dignity and well-being. This also includes education, health, etc., which inspired by socialism in a broad sense. These are considered as rights to be guaranteed. The first generation of human rights is that of civil and political rights. These are rights of the individual to confront the state if it acts contrary to the political freedom of the citizens. Historically, these rights, already in the embryonic British customary constitution, developed in the late 18th century and were recognized during the American Revolution of 1787 and the French Revolution of 1789. These rights include civil liberties, which guarantees freedom to the individual to do anything insofar as it does not harm others. These are as follows. First, right to life. Second, prohibition of slavery. Third, prohibition of torture and inhuman. Fourth, prohibition of arbitrary detention. Fifth, freedom of marriage and of parentage. And sixth, right to property, which is considered by the Declaration of 1789 as a natural and inalienable right of human person. It is stated in Articles 2 and 17. Let's try and understand what are political rights in this venture. Political rights include the following: the right to vote, the right to resistance to oppression, the right of peaceful assembly, including freedom of religion. The second generation of human rights are rights that require government intervention to be implemented. The individual, unlike in the case of resistance, is here able to require the state to take some action. The state must guarantee some rights to its citizens in return for abandonment of a part of their freedom. These are called social rights because they result from the experience of social struggles. Historically, most of these rights have been recognized in the aftermath of the Second World War. Nevertheless, the right to work and to social protection was claimed at the outset of the French Revolution of 1789 and enrolled in the Law of March 1793, which states that every human person is entitled to his or her livelihood through work, if he or she is capable to work, or through free relief if he or she is unable to work. Thus, the care of providing for the subsistence of poor is a national duty. Similarly, Article 21 of the Declaration of Human Rights and Citizen of 1793 affirms that the state owes subsistence to unfortunate citizens, either by providing labor or providing the means of existence for those who are unable to work. There is some conflict between the rights to be safeguarded against the state and the rights to be guaranteed by the state. This is because of the opposition between two conceptions of human rights, liberal and socialist. Universal Declaration of Human Rights of 1948, which upholds rights such as right to social security in Article 22, right to work in Article 23, and right to education, Article 26, is accompanied by two United Nations international pacts on civil and political, first generation, and on economic, social, and cultural rights of second generation in December 16, 1966. Both pacts have rarely been signed together. The countries of the West Bloc signed the first more willingly, while those in Eastern Bloc signed the second. The third generation of human rights revolve around the fundamental principle of equality and non-discrimination. Some of the major concerns are the environmental law, consideration of bioethics, right to development, and right to peace. The fourth generation of human rights states some like Emmanuel Kabla Kwashiga speak of a fourth generation of rights that would be global. So all actors in society would benefit from implementing these rights. However, the content of these rights is not clear. They contain certain rights of the third generation like environmental law and bioethics. However, it is apt to note a significant shift from freedom to substantive equality. The source of law in the field of human rights is the existence of the individual, while the source of law in democracies, by definition, derives from the general will. When these two sources of law conflict, society must find a balance and a way to reconcile these two imperatives. The conflict could be well explained as follows. We have freedom of expression, but the criminal law prohibits insulting a neighbor. Similarly, we have the fundamental right to marry, but civil law prohibits marriage between brothers and sisters in many countries. The laws in the above stated examples do not violate human rights, but it does indeed raise some concerns. It urges us to reflect over the question of what acceptable limits the law may impose on human rights in a democratic society. It is possible that democracy can come into conflict with human rights. The democratic principle makes legitimate a priori any determination made in the popular will and recognizes no higher authority than the rule of the people. Accordingly, there is no universally accepted philosophical, political, or legal solution as satisfactory if the majority of people, directly or through officers democratically elected, would support a policy contrary to human rights. A democratic state can violate human rights. To avoid this, it is generally accepted that they must limit the sovereignty of the people by independent safeguards, a role often taken by the courts, at national level by constitutional judges or by Supreme Courts. Now let us sum up what we have learned in this session. Human rights are the inalienable rights of all human beings, whatever be their nationality, place of residence, sex, ethnic or national origin, color, religion, language, or any other condition. We all have the right to exercise our rights without discrimination and on an equal footing. These rights are interrelated, interdependent, and indivisible. The universal human rights are often expressed and guaranteed by law in the form of treaties, customary international law, general principles, and other sources of international law. International law on human rights states that governments are obliged to act in a certain way or refrain from certain acts to promote and protect human rights and fundamental freedoms of individuals or groups. Thank you, learners. That's all for in this session.